What is ripeness? Ripeness is a justiciability doctrine that asks whether a dispute has developed enough to be heard by a court now, rather than being dismissed as premature. Ripeness keeps courts out of abstract or hypothetical disagreements. In U.S. federal courts, Article 3 limits judges to actual cases and controversies. If a lawsuit challenges a law or policy before its effects have concretely impacted the plaintiff, the case may be unripe. The classic articulation comes from Abbott Laboratories versus Gardner. Courts balance 1. Fitness for judicial decision. Are the issues purely legal and sufficiently crystallized? And 2. Hardship to the parties of withholding review. Will waiting impose real, immediate costs or force a choice between compliance and significant penalties? A little history helps. Early justiciability cases emphasized avoiding advisory opinions. In Poe v. Ullman, 1961, the court refused to hear a challenge to a contraception ban that was rarely enforced, too speculative to be ripe. Abbott Laboratories, 1967, then opened the door to pre-enforcement review when a regulation's meaning is clear and compliance costs are serious and immediate. Later, the court refined boundaries. Toilet Goods, 1967, found no ripeness where the agency might never impose the threatened sanction. Ohio Forestry, Assen v. Sierra Club, 1998, said a general forest plan wasn't ripe because it caused no present legal injury, and National Park Hospitality Assen, 2003, treated an advisory policy statement as unfit for immediate review. More recently, in MedImmune v. Genentech, 2007, and Susan B. Anthony List v. Dryhouse, 2014, the court recognized that a credible threat of enforcement or a coercive dilemma can make a dispute ripe before penalties actually fall. How do you apply it? Start with fitness. Questions purely of law, like whether a final regulation exceeds statutory authority, are usually fit, especially when no further factual development is needed. If facts matter, e.g., how an agency will actually apply a standard, courts are more cautious. Then consider hardship. Are plaintiffs already incurring compliance costs? Must they either change costly behavior or risk serious sanctions? The more immediate and non-trivial the burden, the stronger the case for ripeness. By contrast, a distant, uncertain possibility of enforcement rarely suffices. Ripeness interacts with standing and mootness, but is distinct from both. Standing looks backward to whether the plaintiff has suffered, or imminently will suffer, a concrete injury traceable to the defendant and likely to be redressed. Ripeness looks forward to timing. Is the injury imminent enough and the dispute developed enough to adjudicate now? Mootness asks whether a once-live dispute has gone stale because the injury ended and effective relief is no longer available. Think of the trio as entry, standing, timing, ripeness, and exit, mootness. Pre-enforcement challenges are the ripeness hot zone. Plaintiffs often want to test a law before risking prosecution or heavy civil penalties. Courts ask whether there is a credible threat of enforcement and whether the legal issues are ready for decision. For example, a business challenging a finalized labeling rule that becomes effective next quarter and that requires costly retooling today presents a strong ripeness case. By contrast, a challenge to a draft policy that might change after notice and comment is usually unripe. A few practical examples. 1. An environmental NGO sues over a finalized emissions rule with clear obligations starting in 6 months. Members must buy equipment now. Likely ripe. The issues are legal and hardship is concrete. 2. A developer attacks a city's informal guideline that staff may or may not apply in future permits. Probably unripe. The policy isn't final and factual application is uncertain. 3. A speaker chills her speech because a statute criminalizes certain ads and the prosecutor has enforced similar cases. Likely ripe, credible threat plus immediate self-censorship. Curiosities. A. Ripeness has both constitutional and prudential strands. The credible threat and injury is imminent pieces are grounded in Article 3. The fitness hardship balancing has sometimes been described as prudential, meaning courts use it to manage their docket even when constitutional minima might barely be met. B. Administrative law adds the final agency action requirement under the APA, which often overlaps with ripeness. A rule or order must be final before judicial review, but finality and ripeness, while related, are not identical. Bottom line, ripeness is about timing and concreteness. Courts want disputes that are legally framed and factually developed enough to decide without guessing, and they'll step in early when waiting would impose real, immediate costs or chill protected conduct. Above, you'll find more videos to keep learning law. Remember to leave us a like and subscribe.